Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Picture a federal courtroom in New York.
Okay.
It is late March. The year is 2026. And the atmosphere of these rooms, well, it's usually pretty heavy anyway.
Oh, absolutely.
You know, you have the dark wood paneling, the impossibly high ceilings. There's just palpable, suffocating sense of tension that hangs over the gallery.
Right. It's designed to be intimidating.
Exactly.
Yeah.
But on this specific day, March 30th, the air is practically humming. You have a jury that has been deliberating for days.
And they've been sending cryptic notes to the presiding judge, right? Judge Jesse M. Furman.
Yeah, exactly. And the defendant sitting at the table is Cognizant Technology Solutions. I mean, this is a massive global tech and consulting giant.
We're talking about a company with over 300,000 employees worldwide.
Right, a company bringing in nearly $20 billion in annual revenue.
And sitting on the exact opposite side is just a single individual.
One former employee. So the jury foreperson hands over the verdict form. It's labeled Court Exhibit 8. And the numbers that come down are just absolutely staggering.
I mean, they really are.
The jury checks yes for retaliation. They award $4.2 million in back pay.
Which is a massive number on its own.
It is. But then there's the second number, another $4.2 million. But this time it's for punitive damages. That is an $8.4 million total verdict against a global corporation delivered by a unanimous jury in favor of one single plaintiff.
It's just a breathtaking conclusion.
Welcome to the Employee Survival Guide, produced by Mark Carey.
It really is a conclusion to a legal battle that stretched out over an entire decade.
Yeah, 10 whole years.
Right. And the reason we are examining this today isn't just to, gawk at a multi-million-dollar penalty.
No, not at all.
We are looking at the entire anatomy of a corporate firing. We're looking at the invisible machinery that dictates who gets promoted, who gets sidelined, and how large multinational corporations move human capital across the globe.
Exactly. So today we are unpacking the factual story behind the case of Jean-Claude Franchitti versus Cognizant Technology Solutions Corporation.
And we have a massive stack of federal court documents to guide us through this.
We really do. We are looking at the initial amended complaint, the incredibly detailed 2022 motion to dismiss ruling by Judge Furman.
Which is a fascinating read, by the way.
Well, absolutely fascinating. We also have the highly strategic 2026 pretrial motions in Lampsney and those final jury verdict forms.
So our mission here is to really deconstruct exactly what happened.
Right. How does a star employee, someone who was single-handedly managing a $20 million book of business, how does he find himself abruptly fired?
And how does a sophisticated, legally well-resourced global corporation end up paying millions of dollars specifically for retaliation?
Now, before we go any further, it is really crucial to establish the framework for this discussion.
Yes, very important.
The documents we are reviewing contain highly charged allegations. We're talking about systemic racial bias, national origin discrimination, and federal immigration fraud.
Right. And as we navigate this, we want to be explicit with you, the listener. We are entirely neutral here.
100% neutral.
We are not taking sides, nor are we endorsing the viewpoints or allegations made by either party.
Exactly. Our role is strictly to impartially retort on the contents of the federal court records.
Right, to explain the legal and corporate mechanics that led a jury to this $8.4 million conclusion. We are just here to understand the anatomy of the lawsuit, step by step.
So let's start by laying the foundation. Because before we can even touch the jury's decision in 2026, we have to rewind the clock all the way back to 2007.
Yeah, we really need to understand the baseline of who Jean-Claude Franchitti actually was.
Right, because he was not some struggling, borderline employee desperately clinging to his job.
Far from it. If you read through the performance reviews cited in the complaint, Franchitti was a corporate rainmaker.
A total rainmaker. He was hired by Cognizant in April 2007 as a chief architect within their advanced solutions group.
And for those outside the tech consulting world, an enterprise architect is not the person fixing your laptop when it freezes.
No.
You are designing highly complex, multi-million-dollar technology systems for massive corporate clients.
Right. You are integrating global supply chains, migrating massive data centers, and building the digital infrastructure that allows Fortune 500 companies to even operate.
Exactly. And the margin for error in those roles is practically non-existent.
Oh, I can imagine.
When you are dealing with the technological backbone of global corporations, competence is just the absolute bare minimum.
Right.
And Franchitti exceeded that. From 2007 through 2015, the complaint notes he consistently received exceeds expectations on his performance reviews.
Which, in the rigid hierarchy of giant tech firms, exceeds expectations is a highly protected designation.
Oh, absolutely. It dictates your bonus pool, your stock options, and your entire trajectory in the company.
So he gets promoted to assistant vice president in 2011.
Right.
And by 2012, he is handed the reins of something called the Technology Consulting Team, or GTC. And that operates within the broader global technology office.
The scale of his success here is really what makes the ultimate firing so legally perilous for the company later on.
Right, because he is managing roughly 150 employees.
Yeah.
And he is overseeing a $20 million portfolio of client business.
Think about the entities he is keeping happy here. Walgreens, Nike, the World Bank, the Hartford Prudential.
Those are massive, demanding clients.
Incredibly demanding. And he is achieving exemplary client satisfaction scores and actively adding new logos to Cognizant's portfolio.
So he's undeniably generating massive value for them.
Without a doubt. But then, in 2014, the corporate landscape shifts dramatically beneath his feet.
Oh, boy.
And anyone who has spent time in a multinational corporation knows the anxiety that comes with this next phrase.
Let me guess. The global corporate restructuring.
Exactly, the global corporate restructuring.
I want to break down how these restructurings actually work under the hood, because it really explains everything that follows in this case.
Yeah, it's vital context.
In a massive consulting firm, you generally have two ways of organizing your workforce. You have vertical business units and horizontal business units.
Right.
Vertical units are focused on a specific industry, say like healthcare or banking. Horizontal units, on the other hand, are focused on a specific capability, like cloud computing or data analytics. And they sell those specific services across all the different industries.
That makes sense. And Franchitti's GTO unit was a highly successful horizontal team.
Exactly. Meanwhile, in 2014, Cognizant has another business unit called Cognizant Business Consulting, or CBC.
Right.
And CBC is struggling. They provide management and strategic consulting, but they are just having a hard time gaining traction.
They aren't billing enough hours to clients.
Right. So the executive in charge of CBC, Mark Livingston, makes a strategic play. He decides to attach his struggling unit to the successful horizontal business units.
It's essentially a corporate parasite strategy.
That's a great way to put it.
You have an underperforming group, so you basically graft it onto a high-performing group to absorb some of their momentum and revenue.
Right. So they create a new subunit called CBC GTO. And because Franchitti is already doing this exact type of technical consulting work so successfully, they put him in charge of it.
But here is the structural nightmare this creates.
Yeah.
Franchitti now has a dotted line reporting structure to Mark Livingston, the head of the struggling CBC unit.
Okay.
While still maintaining his solid line reporting to his main supervisor, Raj Bala, who is the chief technology officer and senior VP based in Chennai, India.
Oh, wow. Matrix management structures like this, where you report to two different executives with competing agendas, I mean, those are historically just fraught with problems.
Oh, they are a recipe for disaster. But the structural tension goes much deeper than that.
How so?
At the exact same time that Franchitti is put in charge of this new CBC GTO unit, his primary boss, Raj Bala, creates a brand new competing consulting unit.
Wait, really?
Yes, he creates a unit called GTO Labs.
Okay, let's look at the operational overlap here, because this is wild. GTO Labs is run from India, but it staffs projects in the United States.
Correct.
And according to the complaint, GTO Labs is set up to perform the exact same type of consulting work that Franchitti's CBC GTO team is doing.
Exactly the same.
So you have two leaders, one based in the U.S. and one based in India, overseeing teams that are suddenly competing for the exact same internal resources, the same budgets, and the same clients.
And that structural overlap is the absolute incubator for everything that follows.
Okay, but let me push back on that for a second.
Sure.
Because redundant teams and internal rivalries, I mean, that happens constantly in big business.
Yeah.
Executives build competing fiefdoms to prove whose operational model is superior all the time.
Right, it's very common.
So isn't that just standard cutthroat corporate capitalism? Why doesn't this just stay a ruthless business case study? Why does this structural overlap mutate into a massive federal civil rights lawsuit?
That is the core question. And the transformation from a corporate turf war to a legal liability hinges entirely on demographics.
Demographics. Yeah.
The internal competition itself is perfectly legal, but the legal argument presented to the court was that this wasn't just a battle over revenue models. It was a demographic turf war.
Okay. Unpack that for me.
The complaint alleges that while GTO Labs was staffed almost entirely by Indians of South Asian descent, Franchitti's CBC GTO team had a significantly higher concentration of non-South Asians.
So the structural overlap actually became a racial and national origin overlap.
Exactly. The complaint states that Raj Bala sought to use his ultimate staffing authority to harmonize these two groups.
What a nice.
Right, harmonize. But in this context, harmonization allegedly meant homogenizing Franchitti's staff to reflect the demographics of GTO Labs.
Wow.
It meant actively eliminating or diminishing the non-South Asian employees on Franchitti's team to replace them.
Okay, we really have to understand the mechanisms of discriminatory animus here. Because a demographic imbalance between two teams, well, that could just be a byproduct of organic hiring patterns, right? Or geographic location, or sheer coincidence.
Absolutely.
To prove in federal court that this was intentional discrimination, you need to look directly at the executive running the show. You need to look at the explicit philosophies of Raj Bala.
And this is where the allegations in the complaint become incredibly specific.
Yeah.
You know, in employment law, plaintiffs usually have to rely on circumstantial evidence.
Like what?
For instance, you might argue, well, I was passed over for a promotion and someone of a different race with lesser qualifications got it. Therefore, I want the jury to infer that bias was the reason.
Right, making a leap based on the circumstances.
Exactly. But circumstantial cases are notoriously difficult to win.
Because the corporation can just come up with an excuse.
Precisely. They can almost always provide a subjective alternative reason. They'll say, oh, the other candidate had better soft skills, or they were a better culture fit.
The classic culture fit defense.
Right. But the Franchitti complaint isn't relying just on circumstantial statistics. They bring forward allegations of direct evidence.
And direct evidence is kind of the holy grail in employment litigation, isn't it?
It absolutely is. It is when the ultimate decision maker explicitly articulates a bias that directly relates to the adverse employment action.
Okay, so what did Bala allegedly say?
The documents cite a public speech Raj Bala gave in 2011 to the Confederation of Indian Industry.
Okay.
In it, he essentially discusses the global shift in technological expertise. He says that when it comes to technology, for the first time in the industry, the West is learning from the East.
Which, I mean, if you look at the macroeconomic trends of 2011, a public speech about the rising technological prowess of India is completely standard.
Totally standard.
It just reflects the massive boom in offshore IT services at the time.
Right. He says, we are building the technology and those things are all going to the West for the first time. And this trend will continue.
Okay, but how is that illegal?
It isn't. But the lawsuit juxtaposes that diplomatic public speech with what Bala was allegedly saying behind closed doors in private operational business meetings.
The behind closed doors conversations.
Yes. According to the court filings, Bala would routinely categorize his global workforce strictly by nationality and race.
Wow.
He would refer to Westerners, meaning Americans and Europeans collectively, as Americans, and those who shared his ethnicity as Indians.
Yeah.
The complaint alleges he frequently made blanket statements in meetings such as, Americans are worthless when it comes to technology.
He actually said that. Worthless.
Allegedly, yes. And statements like, Indians are superior or Indians are the masters of technology.
Wow. That's intense. Let's focus on a specific term that becomes the absolute center of gravity for this entire lawsuit, though.
Okay.
The heavyweights.
Yes, the heavyweight.
Because in the standard corporate lexicon, a heavyweight is a compliment, right? It means a top performer,
Yeah.
a major player.
Normally, yes.
But in Bala's alleged vocabulary, heavyweights was a targeted demographic marker.
Exactly. He used it to describe older, highly experienced, non-South Asian Westerners.
We're talking about professionals who had been in the tech industry for decades, living in the US or the UK. And they naturally commanded much higher salaries due to their deep experience and local cost of living.
Right. And the complaint details incredibly specific instances of this language being used to dictate corporate policy.
Like where?
For instance, they point to an in-person meeting on May 13th, 2014. This was at a Marriott hotel in Teaneck, New Jersey.
Very specific.
And later, a pair of meetings in December 2014 at a JW Marriott in Florida, and then another one in Miami.
Okay.
In these meetings, surrounded by other executives, Bala allegedly stated point blank that the heavyweights aren't needed.
He just said they aren't needed.
Yes, and he allegedly justified this by saying their abilities are inferior to Indian workers.
And Franchitti's team was heavily populated by these exact so-called heavyweights, weren't they?
Yeah, very heavily. He had about 15 direct reports based in the U.S. and another 10 based in the U.K.
And these were the highly experienced professionals who were actually executing the complex architectural work that generated that $20 million in revenue.
Right, the ones doing the actual heavy lifting.
Exactly. Franchitti relied on their specific localized expertise to keep highly demanding clients like the World Bank happy.
Yeah.
But, according to the complaint, Bala's stated strategy was to actively eliminate these non-South Asian heavyweights from Franchitti's team, specifically to make room to staff Indian nationals in their place.
Think about the legal exposure of a corporate officer allegedly announcing this plan in a hotel conference room.
It's massive.
It transforms the vague concept of a culture fit into a documented, explicit intention to fire people based entirely on their demographic profile.
It's the equivalent of, a corporate merger, where the acquiring CEO walks into the newly acquired subsidiary and says, look, your profit margins are great, but I only want people from my specific home country working here. Your current staff is worthless to me based entirely on where they were born, so we are going to systematically manage them out.
Which is incredibly illegal.
Exactly. A global corporation simply cannot operate that way under U.S. civil rights laws.
No, they cannot.
But here is the massive logistical hurdle for Bala. An executive bias without a mechanical pipeline is just hot air.
All right.
If Raj Bala wanted to fire all of Franchitti's experienced U.S. and U.K.-based heavyweights, he couldn't just leave those desks empty.
The client work still had to be done.
The revenues still had to be generated.
Yeah.
So Cognizant needed a massive, constant, predictable pipeline of specific talent to replace them.
And according to the complaint, they built that pipeline using methods that plunged the company into severe federal jeopardy.
And this is where the narrative really expands, doesn't it?
Oh, absolutely. It moves from a standard discrimination claim into the incredibly complex world of global immigration law and alleged systemic fraud.
So we have to dive deeply into the logistics of moving human capital across the globe. Specifically, we need to talk about the H-1B visa system.
Yes, because you cannot understand the leverage in this case without understanding how H-1B visas actually work in reality.
Right. So the H-1B is a non-immigrant visa that allows U.S. employers to temporarily employ foreign workers in specialty occupations.
Roles that require theoretical or technical expertise, like IT, finance, or engineering.
Exactly. The H-1B system is designed to allow American companies to fill critical skills gaps when they literally cannot find qualified local workers.
But it is notoriously difficult to navigate.
Oh, I've heard it's a nightmare.
It really is. First, there is a strict annual statutory cap. Congress currently mandates a regular cap of 65,000 H-1B visas per year,
Okay.
with an additional 20,000 reserved specifically for individuals with advanced degrees from U.S. institutions.
But the demand from giant tech firms drastically outstrips that supply, right?
By a mile. We are talking about hundreds of thousands of applications for those 85,000 spots.
Wow.
Because the demand is so high, the federal government uses a randomized lottery system.
So it's literally just luck.
Pretty much. You submit your applications in March or April, and you just cross your fingers. It is unpredictable, it is slow, and it is highly regulated.
And furthermore, before a company can even enter an employee into that lottery, they have to file a labor condition application, or LCA.
Yes, with the Department of Labor.
Right. And in that LCA, the corporation must legally attest to several things under penalty of perjury.
Which is a big deal.
A huge deal. They must attest that they will pay the visa holder the prevailing wage for that specific geographic area, basically ensuring they aren't undercutting local wages.
Right.
And crucially, they must attest that there is an actual specific open job right now for this specific visa applicant to fill.
That is the key point. You cannot apply for an H-1B visa just to stockpile talent.
You can't just hoard them.
No, you cannot say to the federal government, hey, give us 1,000 visas and we will find something for these folks to do once they get to America.
Right. There must be a specific role waiting for them.
Exactly. And this brings us to the explosive allegation at the center of Franchitti's story.
Okay, lay it on me.
The complaint alleges that Cognizant engineered a massive fraud scheme to bypass the unpredictability of that visa lottery bottleneck.
Oh, wow.
Because the visas took so long to process and the lottery was so uncertain, Cognizant allegedly decided to proactively secure visas for fake jobs.
Fake jobs. So they were just making up roles.
Allegedly, yes. And the mechanism they allegedly used to trick the system involved internal documents called invitation letters.
Invitation letters, okay.
To satisfy the government's requirement that a job actually existed, the company needed U.S.-based managers to sign official letters attesting that, yes, I have a specific open position right now on my team for this specific visa applicant.
And the complaint states that Rajbala directed Franchitti to sign these exact letters.
Yes.
And this is a really pivotal moment in the whole story. Franchitti initially complied.
He did.
He signed hundreds of these invitation letters, attesting to the federal government that jobs existed on his team when, in reality, they simply did not.
And the sheer volume of this alleged scheme is staggering. I mean, the complaint notes that in 2013, Cognizant received over 10,000 H-1B visas.
10,000.
Yes. And in 2014, they received over 16,000.
That is an insane amount of visas.
Yeah.
What this created was a massive inventory of what Cognizant internally referred to as a travel-ready bench.
Right.
Imagine the competitive advantage this gives a consulting firm. They have thousands of South Asian employees sitting in India already holding fully approved U.S. work visas, essentially just waiting on a runway.
It's incredible leverage.
The moment a client project opens up in the U.S., or the moment an expensive heavyweight is fired, Cognizant doesn't have to wait 6 months for the visa lottery.
No, they can deploy a cheaper, travel-ready worker to the U.S. tomorrow.
It is an operational dream, but allegedly built on massive federal fraud.
But eventually, the psychology of participating in a scheme like this takes a toll.
Yeah, I wanted to ask about that. Wait, so he's participating in the very scheme he later blows the whistle on? Does that hurt his credibility, or does it make him the perfect insider witness?
It's a great question. We see this constantly in white-collar whistleblowing cases.
Really?
Oh, yeah. Very rarely does a whistleblower walk into a new company on day one, immediately spot a complex fraud, and run straight to the authorities.
That makes sense. It's not usually a movie.
Right. Usually they are part of the system. They are instructed by their superiors to process paperwork or sign forms.
Yep.
They follow orders because it is the prevailing corporate culture, and there is a psychological assumption that the company's massive legal department must have vetted the process.
Right. You assume, I'm just a manager, the lawyers in the C-suite wouldn't let us do this if it was illegal.
Exactly. But as the volume of the fake letters increases, and as Franchitti understands more about the rigid regulations of the H-1B system, the cognitive dissonance sets in.
He starts putting two and two together.
He realizes that this isn't just a corporate paperwork shortcut to speed up staffing. He is personally signing documents that are being submitted to the federal government containing false information.
He is placing himself in severe individual legal jeopardy.
Yes. So he acts. Franchitti starts questioning what he is doing. He complains directly to Rajbala.
Okay.
He questions the legality of the entire invitation letter practice. And ultimately, he draws a hard line. He flatly refuses to continue signing them.
Good for him. So how does the company react to that?
Well, according to the complaint, Bala doesn't investigate the legality of the letter.
Of course not.
He simply transitions the signing responsibility away from Franchitti and hands it to a different manager who is still willing to play ball.
Wow. Just passing the buck.
Exactly. And legally, Franchitti's initial participation, followed by his refusal to continue, is what makes him such a potent threat to the corporation later on.
How so?
If he had never signed a letter, the defense could argue he didn't understand the process or was just guessing about how the visas were secured.
Oh, I see.
But because he participated, he has direct, hands-on knowledge of the machinery. He knows exactly how the fraud operates because he was the one holding the pen.
Right. His refusal to keep signing the letters is the massive turning point in his career.
It really is.
It puts an immediate glowing target on his back. You have an executive in Rajbala who allegedly wants to implement a sweeping demographic shift by replacing U.S.-based heavyweights with travel-ready visa workers.
Right.
And Franchitti is not only loudly defending the heavyweights on his team, but he is now actively refusing to facilitate the very visa fraud mechanism required to replace them.
He is a massive roadblock.
Franchitti has put himself on a high-speed collision course with his boss.
And Rajbala, as a senior VP and chief technology officer, has an incredible arsenal of corporate tools at his disposal to make a subordinate's life miserable.
Yeah, the corporate squeeze.
This is where we transition from the setup of the pipeline into the actual squeeze, the systematic, documented sidelining of a high-performing executive.
The complaint outlines this sabotage in brutal detail. We are moving into 2015 now.
Okay.
Franchitti has drawn his line in the sand over the visas and the staffing. And suddenly, Bala starts actively undercutting Franchitti's ability to do his job.
Remember that $20 million book of business?
Yep.
Bala allegedly starts steering core lucrative clients away from Franchitti's CBC GTO team and handing them directly over to his own competing GTO Labs team.
He is deliberately choking off Franchitti's revenue stream.
Exactly.
And in consulting, your internal power is directly correlated to your billable revenue.
100%.
If your revenue drops, your influence drops. And the sabotage is multifaceted. At one point, Franchitti's team absorbs 20 new employees from another underperforming group within Cognizant.
Right.
But Bala flat out refuses to increase Franchitti's budget to support these new salaries.
So he is saddling him with expenses while starving him of revenue.
Exactly. It is a classic corporate starvation tactic. Furthermore, Bala begins excluding Franchitti from critical executive meetings where strategic decisions are made.
He's icing him out.
He becomes hypercritical of everything Franchitti does, treating him with open disdain in front of colleagues.
All of this quiet sabotage culminates in a highly visible flashpoint. The July 2015 promotion meeting.
Okay, let's talk about this.
Let's analyze how critical this moment is in the timeline. Franchitti has not been promoted since 2011, despite 4 consecutive years of exceeds expectations reviews.
Which is crazy.
He is overseeing massive global accounts. In fact, the previous year, Bala himself had actually nominated Franchitti for this exact promotion.
Wait, really? Before the relationship soured over the visas?
Yes, exactly.
So corporate promotion committees at this level are highly formalized.
Very.
The meeting takes place with several high-ranking executives physically in the room and Raj Bala dialing in remotely from Chennai.
Okay.
Franchitti comes into the room, delivers his presentation, highlights the massive $20 million in revenue he has maintained despite the budget starvation.
Right.
And he highlights the exceptional client satisfaction scores from entities like Walgreens and the World Bank. He makes a data-driven case for his elevation.
And then, as is standard practice in these committees, he is asked to leave the room so the executives can deliberate candidly.
Right. They talk behind his back.
The second the door closes, the dynamic shifts. According to the allegations, Bala uses his ultimate authority to immediately veto the promotion.
Just kills it right there.
He speaks negatively about Franchitti to the other executives, and the promotion is unequivocally denied.
Now, in employment law, proving that a single denied promotion was discriminatory is really difficult, isn't it?
Oh, very difficult.
Yeah.
Because the company will almost always argue it was just a subjective evaluation of leadership skills.
Right.
But statistics strip away subjectivity. Let's look at the data from that specific July 2015 promotion cycle under Raj Bala's authority.
This is the part that blows my mind. The numbers are impossible for a defense attorney to spin.
Let's hear them.
In that cycle, Bala promoted over 70 South Asian employees. Dozens upon dozens of individuals were elevated.
Okay.
And how many non-South Asian employees did he promote in that exact same cycle?
Exactly 1.
Just one. A man named Lawrence Cram.
And if you dig into the context of that single non-South Asian promotion, it actually reinforces the plaintiff's narrative rather than weakening it.
How so?
Lawrence Cram was not a rising star. He had worked at Cognizant for a decade without a single promotion.
Oh, wow.
Furthermore, he had recently suffered 2 severe work-related heart attacks.
So out of an entire division, the only non-South Asian to receive a promotion is someone who had stagnated for 10 years and essentially endured a catastrophic health crisis on the job.
It is the definition of the exception that proves the rule.
Yeah.
It paints a picture of a promotion system that is heavily statistically rigged based on demographic profiles.
So following that denied promotion, the work environment for Franchitti and his remaining team degrades from merely hostile into something actively toxic.
It gets really bad.
In late 2015, Bala allegedly escalates his campaign to purge the heavyweights. He orders Franchitti to offload 3 non-South Asian employees into something called the CDP.
We need to explain the CDP because it is a fascinating and kind of terrifying piece of tech consulting infrastructure.
Yeah, please do.
CDP stands for the Cognizant Deployment Pool.
Okay.
In the consulting world, if you are actively working on a client project, you are billable. You are generating revenue.
Right.
If a project ends and you don't immediately have a new assignment, you are placed on the bench. The CDP is essentially a massive corporate holding pen for unallocated talent.
And the bench is basically a ticking clock, right?
Exactly.
Right.
Consulting firms run on tight margins. They cannot afford to pay high salaries to employees who aren't generating client fees.
Right.
If you are placed in the CDP, you have a very short, specific window, usually just a matter of weeks, to hustle and find another internal assignment.
And if you don't?
If you fail to secure a new role before your time in the CDP expires, you are automatically terminated.
Wow. So being ordered to send high-performing employees to the CDP is often a death sentence for their career at the company.
Yes.
Bala orders 3 non-South Asian employees to the bench to be managed out. And even more aggressively, he allegedly orders Franchitti to get rid of a non-South Asian employee who is currently on approved medical leave for colon cancer.
Which is just awful.
But who fully intended to return to work.
It is a ruthless application of corporate policy. But what makes it legally actionable is the comparative treatment.
Right, the comparison.
To prove discrimination, you have to show that different demographics are treated differently under the exact same rules. The complaint highlights the contrasting story of a South Asian employee named Aftab Chopra.
Let's talk about Aftab Chopra, because Bala allegedly wanted to protect Chopra from the very same CDP benching process he was weaponizing against the non-South Asians.
Exactly.
So according to internal communications cited in the case, Bala quietly moved Chopra to a safe, non-billable internal position.
Specifically to hide him from the CDP system until a lucrative, billable assignment opened up.
And Bala explicitly instructed others that he didn't want the rest of the team to know he was providing this specialized protection.
You have an executive manipulating the corporate machinery to accelerate the termination of one demographic while actively subverting that exact same machinery to shield and protect another.
Now, if you are listening to this and analyzing it purely from a business perspective, you might be thinking, this makes no rational sense.
Right.
If Franchitti was genuinely bringing in $20 million and keeping the World Bank happy, why would an executive like Bala sabotage his own company's revenue?
That's a great question.
Why drive away lucrative clients and kneecap a highly profitable manager just to make a demographic point? It seems completely counterintuitive to the core goal of capitalism, which is, making money.
That is a brilliant observation, and it forces us to re-examine how large corporate fiefdoms actually operate in reality.
Because they aren't always rational.
No, not at all. We tend to think of massive corporations as single, rational organisms constantly maximizing overall profit.
Right.
But they are actually fragile ecosystems made up of individual executives, each trying to maximize their own personal power, control, and operational philosophy.
Okay, that makes a lot of sense.
For an executive like Raj Bala, implementing his specific global operational vision, this massive travel-ready staffing model driven by the visa pipeline, is his overarching strategic goal.
I see.
Achieving total architectural control over his division's demographics and structure supersedes the localized revenue generated by one stubborn manager in New York.
Wow.
To Bala, losing Franchitti's $20 million might just be an acceptable temporary casualty in a much larger war to reshape an entire 46,000-person U.S. workforce in his preferred image.
Control is ultimately more valuable to him than one quarter's profit.
Exactly. So Franchitti is watching his highly successful team get dismantled piece by piece. His own career is completely stalled.
Yeah.
The allegedly fraudulent visa pipeline is continuing to pump workers into the system. He realizes that trying to reason with Bala is just futile.
He's hitting a brick wall.
So he makes the decision to take formal action. He stops arguing with his boss and starts going up the chain of command.
And this decision triggers the rapid chain of events that inevitably leads to his firing.
It does.
So in the spring of 2016, Franchitti starts escalating the issue. He goes to his dotted line supervisor, Mark Livingston, the head of the CDC unit.
Okay.
He lays out the sabotage and the bias. And Livingston takes absolutely no action.
Nothing.
Franchitti then goes higher to a senior VP named Alan Shaheen. Again, nothing happens. He is met with total corporate inertia.
It's just a wall.
Finally, he hits the wall that so many desperate employees hit human resources.
He goes directly to Neil Navarez, the chief people officer at Cognizant.
Right.
Between April and June of 2016, Franchitti meets with Navarez 4 separate times.
4 times.
And These aren't casual check-ins. He lays the entire architecture of the scheme on the table. He details the demographic targeting of his team, the explicit hostility from Rajbala, the mechanics of the fake invitation letters for the visas,
Right.
and his intense growing fear that he is going to be severely retaliated against for blowing the whistle.
Put yourself in the shoes of an HR executive receiving this information.
Right.
You are being handed a ticking legal time bomb regarding federal immigration fraud and civil rights violations by a senior executive.
His massive exposure.
During the first 3 meetings, Nevarez listens. He takes notes. He tells Franchitti he is looking into it.
Standard HR talk.
Exactly.
Yeah.
But the breaking point comes on June 27th. Nevarez finally gets back to Franchitti after allegedly having a private conversation with Rajbala.
Uh-oh.
And Nevarez delivers a response that is just an absolute masterclass in corporate rug sweeping.
Nevarez completely dismisses the substantive discrimination and fraud complaints. Instead, he frames the entire crisis as merely an interpersonal dispute between two executives who just aren't collaborating well.
Interpersonal dispute.
Nevarez tells Franchitti that HR cannot and will not get involved in a simple personality clash.
Think about the psychological impact of that phrase. Interpersonal dispute.
It's gaslighting.
You bring documented allegations of systemic racial bias and federal visa fraud to the chief people officer, and you are told that you just need to play nicer in the sandbox with your boss.
That's wow.
HR is actively neutralizing the threat by reclassifying a federal crime as a bad attitude.
Franchitti must have been furious.
Absolutely furious, and he is terrified. That same night, he calls Nevarez and leaves a frantic voicemail. He explicitly demands that HR look deeper into the discrimination allegations, and he explicitly demands formal protection from retaliation.
And the documentation of that voicemail is critical.
Very critical.
Because the next day, June 28th, Nevarez sends Franchitti a text message acknowledging it. The text reads, "Got your voicemail, I will call you tomorrow."
But tomorrow comes, and the phone doesn't ring.
And the next day, nothing.
Nevarez completely ghosts him. Franchitti tries to reach out multiple times over the next few weeks, begging for an update, begging for the protection he requested.
He gets nothing but absolute silence.
Until July 19th, 2016.
Exactly 21 days after that final voicemail demanding protection.
Franchitti receives a calendar invite to join a sudden phone call with his dotted line manager, Mark Livingston.
Okay.
When Franchitti dials in, he realizes HR Chief Neil Nevarez is also silently on the line.
That's never a good sign.
Livingston does not mince words. He tells Franchitti that he is terminated effective the very next day.
Wow. And what is equally important is what they don't say on that call.
Right.
They offer zero performance-related reasons for the firing. In fact, they affirmatively assure him that the termination is not related to his performance.
But they refuse to provide any other justification.
None. And even more tellingly, they deny him the very corporate safety net they force everyone else into. They do not put Franchitti in the CDP.
The bench. The holding pool that Bala was using to manage out the heavyweights.
Yes.
Even the people Bala wanted gone were at least given a few weeks in the CDP to frantically search for another internal role.
Right.
Franchitti is denied access to the CDP entirely. They just violently cut the cord. Yeah. His corporate email is instantly deactivated. His access is revoked.
And almost immediately, his position overseeing that $20 million portfolio is filled by a South Asian employee named Purna Roy.
Let's analyze the sequence of events purely through the lens of employment law.
Okay.
The timeline here is utterly devastating for the corporation's defense. You have an employee with a decade of documented stellar performance reviews.
Right.
He makes a formal, documented complaint to the highest levels of HR alleging racial discrimination and federal visa fraud.
Huh.
He leaves a voicemail explicitly begging for protection from retaliation.
Yeah.
And just 3 weeks later, he is fired without cause, without process, denied standard corporate offboarding procedures, and instantly replaced by a member of the exact demographic he alleged was being unlawfully favored.
It is the absolute textbook definition of how to trigger a retaliation lawsuit.
Right.
In court, this is known as temporal proximity.
Temporal proximity.
Yes. When the window of time between an employee engaging in a protected activity like complaining about discrimination and the adverse employment action like getting fired is this short, it raises a massive blazing red flag for any jury or judge.
The proximity implies causality.
Exactly. So Franchitti is out on the street. His career at Cognizant is over. But he clearly did not go quietly into the night.
No, he did not.
He immediately takes his massive trove of documentation to the EEOC, the Equal Employment Opportunity Commission.
Right.
And he eventually files a massive lawsuit in federal court. But here is where we need to fast forward and look closely at the 2022 motion to dismiss ruling by Judge Jesse Furman.
Okay, because the lawsuit changed. Right.
Dramatically.
Yeah.
Because a sprawling lawsuit that Franchitti initially filed is very, very different from the streamlined case that finally made it in front of a jury in 2026.
The legal gauntlet a plaintiff has to run between getting fired and actually standing in front of a jury is incredibly brutal, exhausting, and highly technical.
It takes years.
First, the EEOC process itself takes years of bureaucratic investigation. It isn't until February 2020, nearly 4 years after he was fired, that the EEOC finally issues a formal letter of determination.
And they actually agree with Franchitti.
They do. They state there is credible evidence of retaliation against him. And they go further, finding reasonable cause to believe Cognizant was engaging in a nationwide pattern of discrimination.
Armed with a favorable EEOC finding, you would logically assume this case would just settle out of court.
Right, because corporations hate the public exposure of trials.
Especially when the federal government has already found credible evidence of bias.
Right.
And they almost did settle.
They did.
Yes, by July 2020, lawyers for both sides had negotiated a specific dollar amount to settle all of Franchitti's claims.
Okay.
Cognizant sends over the final settlement paperwork. But at the 11th hour, the entire deal violently blows up.
Why? What happened?
It blows up because of standard corporate legal boilerplate.
Oh, classic.
The settlement contract required Franchitti to sign a certification stating he had no other pending claims or lawsuits against Cognizant anywhere in the world.
It's a standard blanket release. The company pays you, and you promise you aren't secretly suing them for something else.
Right. But what Cognizant's HR and employment lawyers didn't know was that Franchitti had been incredibly busy on another front. 3 years earlier, in 2017, he had secretly filed a qui tam lawsuit under the False Claims Act.
Okay, we need to explain the mechanics of a qui tam lawsuit, because it is one of the most powerful and secretive tools in American law.
Also known as Lincoln's Law, right?
Exactly. The False Claims Act allows a private citizen, called a realtor, to file a lawsuit on behalf of the United States federal government, alleging that a company is actively defrauding the government.
In this specific case, Franchitti was using the qui tam provision to officially blow the whistle on the massive H-1B visa fraud pipeline.
The fake invitation letters, the systemic abuse of the immigration system, all of it.
Right. Now, by law, when you file a qui tam lawsuit, it is automatically placed under seal.
Meaning it's secret.
Highly classified. The company being sued is not notified. The public does not know. The seal gives the Department of Justice time to secretly investigate the claims and decide if the U.S. government wants to intervene and take over the prosecution.
Because the qui tam suit was under a federal seal, Franchitti legally could not disclose its existence to Cognizant.
He was bound by federal law.
When Cognizant demanded he sign a blanket release stating he had no other pending claims, Franchitti was trapped.
Yeah.
If he signed it, he would be committing fraud during the settlement, and he would effectively be destroying his own federal whistleblower case regarding the visas.
So he refuses to sign the blanket release.
And Cognizant, unaware of this secret visa lawsuit, refuses to drop the standard clause. The settlement dies right there on the table.
With the settlement dead, Franchitti is forced to take his discrimination and retaliation claims to federal court in New York.
Right.
But Cognizant's defense team immediately deploys a massive legal weapon, a motion to dismiss.
They try to throw the entire case out before it ever reaches the discovery phase, arguing that legally the claims are flawed.
And Judge Furman, in his expensive July 2022 ruling, actually agrees with Cognizant on several massive structural points.
He really takes a legal machete to the complaint and slices the case down significantly.
Let's break down exactly what the judge threw out, because the legal maneuvers here are just a fascinating study in procedural law.
Great for it.
First, Franchitti tried to bring broad discrimination claims under Section 1981 of the Civil Rights Act.
Okay.
Section 1981 prohibits discrimination on the basis of race in the making and enforcing of contracts, including employment.
Right.
But there is a strict 4-year statute of limitations. Franchitti filed his New York lawsuit too late. The 4-year clock had expired.
Oh, okay. But Franchitti's lawyers anticipated this, right? They tried to argue that the clock should have been paused.
The legal term is told.
Told. They argued the clock was paused because During those 4 years, Franchitti was attempting to join a massive nationwide class action lawsuit against Cognizant that was happening out in California.
Known as the Palmer case.
The Palmer case.
Yeah.
Which was also alleging systemic discrimination by Cognizant against non-South Asians.
Franchitti relies on a highly specific legal doctrine known as American pipe tolling.
American pipe tolling?
Yes. This stems from a 1974 Supreme Court case, American Pipe and Construction Company v. Utah.
Okay, lay some Supreme Court history on us.
The Supreme Court created this doctrine to solve a massive logistical nightmare in the port system. The rule basically says, if a class action lawsuit is filed, the statute of limitations clock automatically stops ticking for every single person who might eventually be a member of that class.
Which, I mean, the logic makes perfect sense.
It does.
If American pipe tolling didn't exist, the moment a class action was announced, thousands of individual plaintiffs would just panic about the clock running out.
Right, they'd flood the courts.
They would rush to file thousands of identical individual lawsuits just to protect their rights while the class action was being sorted out. It would completely clog and destroy the federal court system.
So the Supreme Court said, don't panic. The clock is paused for everyone until the class certification is decided.
So Franchitti argues, the Palmer class action in California paused my clock, therefore my Section 1981 claims in New York are still valid.
But Judge Furman rules against him.
Why?
He rules that American pipe tolling does not save Franchitti, because the core legal theories were fundamentally different.
What were the theories?
The California class action was built on a theory of disparate impact.
Disparate impact?
Yes. Disparate impact is a statistical argument. You are alleging that a company's neutral policies, like a specific hiring test or a broad HR policy, have a disproportionately negative statistical impact on a specific protected class, even if you can't prove intentional malice.
You prove disparate impact with giant spreadsheets and economists.
Exactly. But Franchitti wasn't just claiming he was a victim of a statistical anomaly. He was trying to sue for retaliation and disparate treatment.
Exactly. And those require entirely different types of proof.
Yes, they do.
The judge points out that defending a retaliation claim is a highly individualized process. It requires investigating specific, localized, protected activities.
It requires looking at the specific HR voicemails left for Neil Navarez.
Right. It requires analyzing the exact 21-day timeline of Franchitti's specific firing.
Because the underlying evidence required to defend the claims was fundamentally different, the broad class action in California did not put Cognizant on sufficient legal notice to preserve the specific emails, voicemails, and evidence regarding Franchitti's highly individualized retaliation.
The legal overlap wasn't tight enough.
Therefore, the tolling did not apply. The Section 1981 claim is completely thrown out. It's time-barred.
Man, losing the Section 1981 claim is a huge blow. Then Franchitti tries a wildly creative argument to save the case. He claims that when Cognizant refused to remove the blanket release clause and essentially walked away from the 2020 settlement, that act itself was a brand new form of retaliation.
He essentially argues, you pulled the settlement money off the table to punish me for my secret visa fraud lawsuit.
That's a fascinating argument.
It is an incredibly inventive argument. He is trying to frame the breakdown of standard contract negotiations as an actionable employment penalty.
I mean, think about it from a layman's perspective. If a company owes you money or offers you money and then pulls it specifically to punish you for blowing the whistle on federal fraud, isn't that the very definition of retaliation?
It feels like retaliation morally, sure, but legally the judge firmly rejected it.
Because it's a settlement.
Right. Under employment law, to legally prove retaliation, you must prove that you suffered an adverse employment action.
Okay.
That means something that materially harms your working conditions, your salary, or your career prospects, like being fired, demoted, or having your pay cut.
And Judge Furman ruled that you simply are not legally entitled to a settlement.
Exactly. A settlement is a voluntary contract negotiation. A company refusing to settle on terms that are highly favorable to the plaintiff does not constitute an adverse employment action.
When the settlement fell apart, Franchitti wasn't materially harmed. He was left in the exact same legal position he was in the day before the offer was made.
He still had the right to sue.
So that failure to settle claim is tossed out as well.
So after the judge's machete finishes cutting through the complaint in 2022, what is actually left standing?
Yeah, much.
Almost the entire sprawling narrative is gone. The hostile work environment claims are abandoned. The Section 1981 claims are time-barred. The failure to settle claims are dismissed.
The only thing left standing, the sole battered survivor of this multi-year legal gauntlet, are the claims under Title VII of the Civil Rights Act and the New York State Human Rights Law.
Specifically, the claim that the termination itself on July 19, 2016, was a direct act of retaliation for complaining to HR about discrimination.
So the sprawling epic has been narrowed to a laser focus. It all comes down to the mechanics of the firing.
And so the parties march toward a trial date in March 2026.
But before a jury is ever allowed to set foot in the room, the lawyers engage in one final, brutal pretrial chess match.
Yes.
This brings us to the fascinating 2026 motions in limine.
We have to understand what a motion in limine is because trials are won and lost in these pretrial hearings.
Tell us what it means.
A motion in limine is a formal request to the judge to legally ban certain pieces of evidence or certain topics from ever being mentioned in front of the jury.
Banning evidence.
Right. The argument is usually that the evidence is irrelevant or that it will unfairly prejudice the jury and distract them from the core legal question. It is where the physical boundaries of the trial are drawn.
And Cognizant's high-powered defense lawyers filed motions attempting to hide a massive amount of context from the jury.
They did. First, they wanted to introduce evidence regarding Franchitti's deep past. They wanted to show the jury that 2 decades ago, Franchitti had filed somewhat similar employment lawsuits against former employers, including J. Crew and Bloomberg.
Oh, wow. The defense strategy is obvious. They want to paint him as a serial litigator.
Exactly.
A disgruntled professional victim who just sues everywhere he works the moment he doesn't get his way.
But Judge Furman grants Franchitti's motion to strictly ban that evidence from the courtroom.
Why?
He cites Rule 404B of the Federal Rules of Evidence. Rule 404B explicitly prohibits propensity inferences.
Propensity inferences.
Yes. This is a foundational concept in American law. You cannot introduce evidence of a person's past acts simply to prove that they have a general character trait or a propensity to act a certain way in the present.
You can't say, he sued 20 years ago, therefore this current lawsuit must be frivolous.
Right. Furthermore, the judge notes that lawsuits from 2 decades ago have absolutely zero probative value regarding what Raj Bala and Neil Navarez actually did in 2016.
Letting the defense drag the jury through 20-year-old HR disputes at J. Crew would just be a highly prejudicial, muddying distraction.
The jury must focus on Cognizant, so the past lawsuits are banned.
Okay, so Cognizant loses that motion. But they win a different, highly strategic one, don't they?
They do. They successfully convinced the judge to ban any mention of a specific bitter dispute over Franchitti's American Express corporate expense account.
The corporate card. During his time at Cognizant, Franchitti apparently got into a heated dispute over his expenses.
He did. And the judge strikes a very fine balance here.
Nice.
He rules that Cognizant is allowed to show the jury specific emails where Franchitti was allegedly insubordinate or rude to his manager regarding the expenses.
Okay, so they can show he was difficult.
Right. The defense is allowed to use those emails to argue, look, we didn't fire him for blowing the whistle. We fired him because he was insubordinate and difficult to manage.
However, under Rule 403, which balances the probative value of evidence against the danger of unfair prejudice, the judge strictly bans the actual credit card statements themselves and the complex financial details of the underlying dispute.
He prevents the trial from devolving into a forensic accounting argument over hotel bills.
Yeah, he explicitly calls the financial details a distracting sideshow.
The judge is aggressively pruning the narrative. He is ensuring the jury only hears evidence directly related to the core question. Why was he fired? Was it retaliation or was it performance or behavior?
But the most critical motion in limine, the battle that essentially defined the outcome of the trial, was Cognizant's desperate attempt to ban Franchitti from talking about the H-1B visa fraud.
Cognizant filed a massive motion, arguing that the visa pipeline should be entirely excluded from the trial.
Excluded entirely.
Yes, their argument was structural. Your Honor, this specific trial is about Title VII retaliation for complaining about racial discrimination. The fake invitation letters and the visa practices are federal immigration issues. They are not race issues. Therefore, mentioning the visa fraud will just inflame and confuse the jury. It has no place in a Title VII trial.
And this is where the judge delivers a fatal, devastating blow to Cognizant's entire defense strategy.
He really does.
Judge Furman outright denies Cognizant's motion. He rules that Franchitti's complaints about the illegal visa practices are inextricably intertwined with his Title VII retaliation claim.
Let's examine why the judge made that connection. You cannot separate the demographic bias from the mechanical pipeline that enabled it.
Right. Think of it like a stage play, right? The judge is the director deciding which props are allowed on stage.
Okay, good analogy.
The racial discrimination ball's desire to purge the non-South Asian heavyweights is the script. It's the motivation. But the visa fraud, the massive illegal pipeline of travel-ready replacement workers, that is the main prop that drives the action. Exactly. If you remove the visa fraud prop from the stage, the entire motivation for the play's climax of firing makes absolutely no sense. Why would Raj Malik care so intensely about firing his highly profitable heavyweights if he didn't already have a massive visa-fueled bench of cheap labor sitting in India waiting to instantly replace them?
The systemic fraud is the exact mechanism that powers the demographic discrimination. The judge recognizes that you simply cannot tell the true story of the firing without explaining the fraud that Franchitti refused to participate in.
With that ruling, the stage is set exactly how the plaintiff needs it to be.
It is.
When the trial finally begins on March 23, 2026, the jury gets to hear the complete, highly focused, incredibly potent story.
They hear about a high-performing architect who built a massive portfolio,
Uncovered a massive corporate fraud pipeline.
realized the fraud was designed to serve a systemic racial bias,
Begged the chief people officer for protection.
and was abruptly fired and replaced 3 weeks later.
Which brings us back to the suffocating tension of the final days of March 2026.
The trial has concluded. The lawyers have made their closing arguments.
And the jury is locked in the deliberation room. And we actually have access to the specific handwritten notes the jury sent to Judge Furman during their deliberations.
Which is so rare and so cool.
It gives us a real-time window into their psychology. On March 30th at 11:52 a.m., the foreperson sends a note that reads, "Good morning, Judge Furman. We would like to have the numbers of all exhibits pertaining to medical records. We have looked, but think we are missing something."
If you are a defense attorney sitting in the courtroom, that note sends an absolute shiver down your spine.
Why is that?
It is a massive neon indicator of exactly where the jury's head is at. Notice what they aren't asking for.
Right.
They aren't asking for more emails about Franchitti's performance reviews. They aren't asking for clarification on the timeline of the visa letters. They are asking specifically for medical records.
This tells us definitively that they have already moved past the question of liability.
Exactly. They have already unanimously decided that Cognizant is guilty of retaliation.
They are now in the math phase.
The math phase. They are calculating damages, specifically damages for the severe emotional and physical distress the corporation inflicted on this man.
So the judge responds to the note, pointing them directly to Plaintiff's Exhibit 187, which are the highly detailed medical records from Dr. Marina Gafanovich.
Right.
He also clarifies for them that Defense Exhibit 65, which were records from NYU Hospital Center, were discussed during the trial, but never actually formally admitted into evidence.
Those medical records tied directly back to the catastrophic physical toll this entire ordeal took on Franchitti.
Yeah, the complaint details how the toxic environment, the daily sabotage of his business, the isolation, and the abrupt, humiliating firing led to severe panic attacks, debilitating post-traumatic stress, and deep depression.
At one point, the stress was so acute and physically overwhelming that he was rushed to the emergency room at Tisch Hospital in New York City.
The jury is staring at the clinical, medical documentation of a man whose life and nervous system were derailed by a corporate agenda.
Less than 2 hours after asking for those specific medical records, the deliberation ends.
Fast.
Very fast. At 1:44 p.m., they send their final decisive note. Judge Furman, good afternoon. We have reached a verdict.
And we can walk right through Court Exhibit 8, the official verdict form. Question 1. Has Dr. Franchitti proved by a preponderance of the evidence that Cognizant is liable for retaliation? The jury circles yes.
Question 2. Is he entitled to compensatory damages? They circle yes. The jury determines the exact amount to compensate him for back pay, lost bonuses, and the emotional distress detailed in those medical records.
And the number is exactly $4,200,000.
And then, question 3. This is the hammer blow.
Has Dr. Franchitti proved that he is entitled to punitive damages because of Cognizant's retaliation? He circled
This
yes.
is the amount they choose to levy.
Another $4,200,000.
A perfectly matched amount, the exact same massive number for back pay as for punishment.
We need to analyze what a matching punitive damage award actually signifies in the eyes of the law.
Because it is incredibly rare and highly symbolic.
Compensatory damages. The first $4.2 million are purely about making the plaintiff whole. It replaces the decade of salary, the lost stock options, and the medical bills he incurred because he was unlawfully fired.
It is an economic calculation?
Right. But punitive damages have absolutely nothing to do with compensating the plaintiff.
Nothing at all. Punitive damages are a weapon wielded by the jury to actively punish the corporation.
When a jury matches the compensatory damages dollar for dollar with a multi-million-dollar punitive strike, they are sending a profound, unmistakable message to the boardroom.
They are saying what you did wasn't just a technical violation of employment law, it was malicious. It was reprehensible.
Right. And we are going to extract an additional $4.2 million from your corporate coffers, specifically to make it hurt, to ensure that your executives feel the financial sting of this verdict and to force you to permanently correct the systemic behavior.
The overarching irony here is just dripping.
It really is. You have a powerful executive, Raj Bala, who allegedly orchestrated this massive, highly complex, legally perilous visa scheme, specifically to save the company money.
He wanted to swap out the expensive, experienced, U.S.-based heavyweights for a pipeline of cheaper visa workers.
He fires Franchitti specifically to protect that cost-saving mechanism, and that single arrogant decision ends up costing the corporation $8.4 million in a single afternoon.
They spent millions of dollars in legal fees and jury awards trying to save thousands on payroll.
It is the ultimate multi-million-dollar cautionary tale of corporate hubris.
The executives believed the machinery they built was simply too big, too insulated, and too legally protected to be challenged by one single employee.
It is an incredible, exhausting journey. We just traced the path of a man who spent years meticulously building a $20 million business, only to find himself trapped in a matrix of demographic engineering.
He uncovers a massive federal visa pipeline. He actively refuses to sign fraudulent documents. He begs the chief people officer of a global corporation for help.
And he is thrown out on the street. He fights through years of EEOC delays, blown multi-million-dollar settlements, and a gauntlet of grueling legal technicalities just to finally stand in front of a jury of his peers and win total, unequivocal vindication.
The takeaways for anyone listening to this, whether you are an executive, an HR professional, or an employee, are crystal clear.
First, document absolutely everything.
Yes. Franchitti's ability to recall specific dates, specific quotes from Marriott hotel meetings, and the exact timeline of HR voicemails is what saved his case when the judge was aggressively cutting down the claims.
Second, understand the hidden mechanisms of your company's staffing models.
Often, the reason you are being sidelined or starved of resources has absolutely nothing to do with your individual performance and everything to do with a global macroeconomic spreadsheet you aren't allowed to see.
And finally, deeply understand that human resources is not your lawyer.
No, they're not your friend. HR's primary fiduciary duty is to protect the corporation from liability, not necessarily to protect the individual employee seeking justice.
When you report severe systemic issues, you must recognize the precarious, highly exposed position it immediately puts you in.
But we want to leave you with a final, broader thought to ponder as we close this out.
Yeah.
We just spent this time looking at one man who had the immense fortitude to fight for 10 years to get his specific story told.
Right.
But in an increasingly interconnected, globalized workforce, massive multinational corporations possess unprecedented power.
They have the ability to move human capital across international borders like chess pieces to maximize efficiency, leverage tax codes, and exert total control over margins.
But when human beings are treated as interchangeable widgets, when they are coldly categorized by their nationality, labeled as disposable heavyweights or deployable travel-ready assets, and swapped out to fit an executive's specific cultural preference, at what point does the ruthless pursuit of corporate efficiency cross the line into systemic erasure?
If it took a decade of brutal litigation, a sealed federal whistleblower suit, and an $8.4 million federal jury verdict to bring this single, isolated instance to light. Imagine your own industry right now. How many invisible heavyweights are being quietly forced onto the bench today?
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey at capclaw.com. That's capclaw.com.